Today we gaze through the crystal to examine how infants judge a book by its own cover, but often get it wrong. A new drug which might just inspire old memories. But first, we dig into the philosophy of life and death itself. You are entering the world of the prism. A look through this prism might just be cracked. Capital punishment may seem an odd fit for the prism, a show that focuses on science, health, and technology, and usually celebrates how we have entered the land of science fiction. But every so often, interspersed with the wonders of advances, there are retreats and even what some might call dystopia. So today, I'm going to look through the prism under America's Armour with our good friend Jody Armour, a professor of law at the University of Southern California. Welcome, Jody.
Good to be back with you, Andrew.
So one of the most basic philosophical debates in human history is that tug of war between thou shalt not kill, or more appropriately, thou shalt not murder, and an eye for an eye. How does society, philosophy, and the law reconcile those thoughts?
Oh, yeah. It comes up a lot when you think of the eye for an eye part of the equation, plays a big role in victims' rights movements and victim impact statements that come into criminal trials. And the victims, a lot of times, get to determine more and more the sentence that is meted out to a guilty defendant. So it seems that we're encouraging punishment as retaliation, punishment as revenge in some sense from that perspective. So there is one approach to justice that says an eye for an eye is the appropriate measure of punishment and for any wrong. On the other hand, Andrew, if someone is driving down the street and causes the death of a pedestrian, do we kill that person who caused the death of the pedestrian in order to keep the scales balanced? Well, what if the person killed the pedestrian because they had a heart attack? Well, they still caused the death. What if they killed the pedestrian not because they intentionally wanted to run down the pedestrian, but because they were playing with their iPod, inadvertently messing with their radio, not keeping a proper lookout, like millions of people do every day? We may still think that they should be punished to some extent for their negligence, but we might not think it's appropriate to kill them because they caused the death. So an eye for an eye approach is a little simplistic. The way the criminal law approaches matters is to say you need both an actus reus, that is, you need to cause a harm like death, and you need mens rea, that is, subjective culpability, inner wickedness that must accompany the actus reus, the prohibited act, before you have a crime for which someone can be punished. So criminal law takes subjective blame very seriously.
But even though that's what the law purports to do, there are certain layers of philosophy or cultural or history which layers on top of that. For example, we know that if you are in a case involving murder, it is far more significantly likely that you will face the prospect of a death penalty if you are a certain shade or color, right?
Yeah, well, that gets to how do we make our moral judgments? How do we determine that someone is wicked, Andrew? You know, in what way do we come to the conclusion that you are more or less culpable? Well, what we do is we use the reasonable person test in the law. The jury is told to ask themselves if a reasonable person in the defendant situation could have been tempted to do what the defendant did or have done what the defendant did. So the jury is asked to either sympathize with the defendant or not sympathize. To the extent that you sympathize with the defendant, you sympathize with his story, you sympathize with the pressures that made him do what he did, you're going to mitigate or exculpate that defendant under the criminal law. On the other hand, to the extent that you don't see any mitigating factors, you think that no, a reasonable person wouldn't have done that, you don't feel sympathy for the defendant, then you inculpate. And what we found is that juries inculpate Black defendants more readily than similarly situated white defendants. We make moral judgments in a racially differential way, surprisingly, perhaps to some. And this is scientifically, kind of through psychological studies, social cognition, especially, which uses social psychology and cognitive psychology, their intersection to, investigate human cognition with, in a laboratory setting that gives you a chance to really catch bias when it can't hide. And what we found through these studies and through our own everyday experience, really, if you reflect on your own experience, is that Black hearts are judged more harshly than similarly situated white hearts for the same prohibited act. And judging hearts is at the core of the mens rea analysis in the criminal law. That's what the jury is required to do. Even though they don't always acknowledge that in the case books, that is what the jury has to do.
So I want to come at you as a social scientist for a moment, because I hear that problem and I think of the general bias in scientific design, experimental design that comes up all the time. You don't want your subjects, when you're writing an experiment, to be known, because then the people filling out the judgment on how they're reacting, how they behave, there might be grading bias. So, and this happens because a law case is also an experiment to a degree. It's a social experiment. So the most basic strategy is to blind the subjects. In other words, the experimenters don't know that Joe was gave this set of answers, or Mary was, or Alfonso was, or anyone else. But we just don't know who they are. Is there a value in possibly only hearing the voices, not seeing the faces? Have we ever tried having a blind jury?
I think that is a brilliant point, suggestion, idea, Andrew. And I think the day for that is coming. I think as we learn more and more from social science about how pervasive and even ubiquitous bias is, especially unconscious bias, the kind buried in the cognitive unconscious, right, below our awareness in any way, and how much that drives our social perceptions and our moral judgments. As we more and more appreciate that, in order to give fair and impartial justice under the law, we're going to have to find ways to help people combat their cognitive biases, to help jurors de-bias themselves before they make judgments of life and death on fellow citizens. So I think we got to get there. We're not there yet. I don't think we take the unconscious bias problem seriously enough yet. But I think as the science keeps mounting, the case for it will become, stronger and stronger. Now, right now people say, oh, but I just gotta be able to make credibility assessments by seeing how the person moves and how he shifts his eyes and those kind of things that would be lost if you just have the voice. But I still think that your point should be explored. We can maybe come up with some tailored ways to both allow for an assessment of the veracity and credibility of the witness, but an avoidance of being unconsciously undermined in your objectivity by the racial identity or sexual identity or social identity in general of the litigant that you have to make this important judgment about.
So what I'm hearing from you in very simple terms is when we come to these judgments in a courthouse, we're very often relying more on, or somewhat equally on possibly, qualitative data as quantitative data. And therein lies a very significant danger.
That's it. That's absolutely it. We're making discretionary judgments based on our moral assessment of the character of this particular wrongdoer. We're saying, are you wicked, or should we feel compassion for you, or should we feel some sympathy for you? We make our moral judgments in the courtroom, Andrew, not on the basis of the categorical imperative, not by logically deducing rights and duties from some abstract formula. Rather, we make our moral judgments in the courtroom, in the jury box, these studies show, on the basis of sympathy, on the basis of empathy, on the basis of, can we say, there but for the grace of God go I, on the basis of whether they see you merely as expressing human frailty, ordinary human frailty under severe pressure, or rather as expressing deep wickedness that deserves moral condemnation and punishment, if not death. So yeah, it's a very flexible, open-ended judgment that the jury is given a free rein to unconscious cognitive biases that we're learning more and more about from the social sciences, especially empirical psychology.